Is cold calling the DNC list legal? Is it illegal to cold call someone on the DNC list? If you talk to any big real estate wholesaling softwares outside of X Leads, they'll say, don't call the DNC list. If you talk to some real estate wholesaling gurus, they'll tell you, don't call the DNC list, or some say, do it. Some say it's in a gray area, sometimes it isn't. What I want to do is put this all to rest. Nobody really has a clear, definitive answer on should you call the DNC list or not until today. I've seen wholesaling gurus say, you're gonna get sued, you're gonna get attacked for cold calling the DNC list. And I mean, as someone that's done a lot of cold calling, I've never been attacked once. So what I want to do today is show you case law, actual court cases of sellers suing wholesalers saying, you cold called me on the DNC list and I'm going after everything against you. And we're gonna see exactly what happened in these court cases so you can know definitively from actual judges, should you cold call the DNC list or not? I'm not gonna give my personal opinion. I'm just gonna show you the facts of what happens when sellers sue you wholesalers, and me wholesaler too, of breaking what we call DNC law or TCPA law. So we have to understand is the DNC list, the do not call list, was established because of the Telephone Communication Protections Act of 1991. Now I know it's boring to death, but that's basically what it is. The TCPA law created a DNC list so you can't solicit. Now, for years and years now, I've been telling you that if you go and look at the DNC list, you can't call somebody if you're telemarketing them. And I'm like, well, what's the definition of telemarketing? Because in wholesaling, I'm trying to give people money, right? I'm not trying to sell them something. Like I'm not trying to sell a stock service or anything like that. And you might want to ask yourself, like, why can't real estate agents cold call the way us wholesalers can? And the truth is because real estate agents are selling a service. They're selling their services of being a buyer's agent or listing the property. And I thought it was always weird why real estate agents don't ever just do what wholesalers do. And then I realized after looking at the definition of telemarketing from the FCC, telemarketing technically is to encourage the sale of a good or service to a person. That's what telemarketing is. And us wholesalers were always in a gray area here. But until recently, I've seen a lot of case studies from bigger wholesalers getting sued. And let's just look at the data and look at the raw facts. So the first case I want to show you is a very interesting one. This one is called Josh M. Jance Plaintiff versus Home Run Offer LLC. This was a legal court case, July 29th, 2021, that seems like it wrapped up in 2022. And this one is a very, very interesting case. And this is one I think I try to tell everyone about it because I think it's such an interesting one. Where basically Mr. Jance here sued Home Run Offer LLC, which is, I believe, a house flipping and a wholesaling real estate company. And it's ran by, I believe, a YouTuber, what I can see here. And pretty much what happened here is this YouTuber was, I would say, they got a decent amount of subscribers, and the seller decided, well, this guy has a big following on social media. I can probably go after him for a bunch of assets. And this is kind of the issue you run in when you become an influencer, right? People think you have all this money, which most of the time you do, and they feel like they can just make money off of you on a lawsuit. And so basically, let's read through this, and I'm just going to show you the facts because whenever somebody says, oh, can I call the DNC list or not? I'm sending this video. This is another reason why I'm making this video, so I don't have to go out here and make 20,000 explanations about this. And so let's read the summary here. The summary says, in Jance v. Home Run Offer LLC, the court held that calls to the plaintiff's cell phone seeking to determine his interest in selling his home and not to induce. So pretty much the summary of this was I'm just going to give you basically the whole thing really quick and then we're going to break it down. But the summary is, in Jance v. Home Run Offer LLC, the court held that calls to the plaintiff's cell phone seeking to determine his interest in selling his home and not to induce a purchase by the plaintiff were neither telemarketing nor solicitation. And so you kind of already see what happened here. If I call the seller and say, hey, I want you to buy a house, that's inducing them to purchase something, right? To buy a house, to buy my service at the massage parlor, go buy my smoothies at my smoothie company, right? That's telemarketing. But for me to just ask, are you looking to sell your house, is not solicitation because I'm genuinely curious and I just want to give you money for the house. Pretty simple. And so let's kind of read a little bit about this, right? You got the whole opinion. Like, you can go read the entire thing right here and search it up. But pretty much the background you have to know here is the plaintiff is trying to sue Home Run Offers LLC for violating TCPA law. And so plaintiff alleged Home Run Offer made 29 calls, which I have to give you this. That to call 29 times for a seller, that takes some guts and a lot of follow-up. So shout out to Home Run there. And pretty much what Home Run Offers LLC did here was try to get a dismissal from what I believe here. Again, I'm not a lawyer, but they got it granted. And pretty much you can read the whole background, what happens. There's a recorded message. Thank you for contacting us. Press 1 to receive a cash offer on your home. Press 2 to be removed from our list. And that's actually pretty good marketing. And it's pretty clear that this Home Run Offers LLC was looking to, my guess, wholesale the house or to buy it and fix and flip it. I don't think there's really anything else you can see here. Now, the court was about to go into some processes here. And what I can see here is the defendant, the wholesaling company or the real estate company, was trying to get a motion to dismiss due to a false claim. And pretty much this is the one that kind of killed the whole plaintiff attacking you for DNC. And this is one we're going to get into details right now. But it basically says, plaintiff fails to state a claim for a TCPA violation under section 227C. Now, I'm not trying to bore you to death, but let's just kind of get the information. Defendants argue that plaintiff fails to state a claim for solicitation or telemarketing under 227C because plaintiff fails to establish that the calls constituted telephone solicitation or telemarketing as defined by the TCPA. The court agrees. Now, this is really interesting here, FYI, because I've been saying this forever, that how us wholesalers trying to get a cash offer in someone's home does not constitute solicitation or telemarketing. Now this goes before a judge and we actually get to see the answer, right? So basically saying to state a claim under 227C, plaintiff must plausibly allege that defendant continued initiating solicitation after his request to be put on the DNC list. TCPA was designed to protect residential telephone subscribers' privacy rights to avoid receiving telephone solicitations to which they object. Now, this is where it gets interesting. The statute defines telephone solicitation as the initiation of a phone call or message for the purpose of encouraging the purchase or rental of or investment in property, goods, or services being offered. Section 227, parentheses A, parentheses 4. Federal regulations which implement the methods and procedures for protecting the privacy rights set forth by the TCPA define telemarketing as the initiation of a telephone call or message for the purpose of encouraging the purchase of a rental of or investment in property, goods, or services which being offered. Now, this is the FCC law. So you see that 47 CFR 64.122 F13. I mean, you guys get that. Neither definition encompasses a scenario in which the caller offers to buy something from the recipient of the call. They even state some case law, which you can even get into crazier, Nunston versus Blue Light. Moreover, the regulation's wording is aimed at calls that directly advertise and not calls that are related to in some intentionated way of advertising or telemarketing the call intends to conduct in the future. Here, plaintiff alleges that the purpose of the call was to purchase plaintiff's home, not to induce plaintiff to make an offer from the caller. Because TCPA clearly defines the term solicitation and telemarketing, and that definition does not include offers to purchase, plaintiff fails to state a claim. So they're basically saying that we're not inducing the seller to make a purchase, but we're actually offering to buy their house. And the judge here on section 3 here, I believe, basically says the plaintiff is failing to state a claim of liability. We get the whole thing of vicarious liability, but to conclude it, they're granting a motion to dismiss, and it gets dismissed. Because it is ordered defendant's motion to dismiss is granted in part and denied in part, the motion to extend that plaintiff's claims against All-Star Investments and Home Run Offer are dismissed without leave to amend. Now, this is really interesting because now this shows case precedent for us wholesalers to call on the DNC list. Now, this isn't a big, go call the DNC list. There are certain ways you got to do it, right? For giving somebody a cash offer on their home and seeing if they're interested. From what I see here, you can do it no problem. This does not mean you can go out here and cold call every single person that is on the DNC list or text them no problem. One thing you got to be very careful of, if you are a real estate agent and you're actually a licensed and you have a broker, theoretically, you could be asking if they're looking to sell their house, because you could theoretically provide a service of listing the house, which could probably get you in trouble. So what I'm going to say is, if you are a licensed real estate agent, yes, you can technically say, no, I'm not putting my realtor hat on. But theoretically, a seller can sue you and say, yeah, he was asking me if I was interested in selling my home, but he was a licensed real estate agent, so he was asking because of that. That's your issue. If you're not licensed, you're not calling someone because you want to go list their house, because that's technically illegal. So there's a very clear difference here if you can call the DNC list or not. And from this case law, it's pretty clearly stated that if you're a wholesaler, you're pretty much good to go if you are not a licensed real estate agent. Because if you're a licensed real estate agent, technically you could be looking to wholesale it, but you also technically could be trying to get a listing fee or selling your service as a realtor. So I'd be very, very careful of this. This is why wholesalers who don't have a license do a lot better than wholesalers that are licensed. Just my 2 cents here. So guys, let me know in the comments, what do you think about this law? Do you think wholesalers are good to go with DNC or not? I'm gonna tell you right now, I think cold calling the DNC list probably feels more comfortable than ever after actually having established case law for us wholesalers. Guys, let me know what you think, and make sure you guys smash that like button, subscribe, and I'll see you soon. This is Zach signing out. Have a blessed one.